During the parties' meeting, the conference call, defendants counsel claimed that TOVE first cause of action for declaratory relief should be dismissed for a lack of pending controversy because defendants purportedly did not and were not planning to dispute that TOVE claimed to joint ownership of the Nopixel server. Okay, and I said, wow. In other words, there was no need for TOVE to seek declaratory relief because the defendants were waving the white flag and acknowledging that TOVE's joint ownership of the Nopixel server. So when I read that, and then we fast forward, we saw the amended complaint basically reiterating this, and then we jumped straight to the motion being mute. All right. When I was on Koil stream, I was like, that's odd. I didn't see another thing. And then when I went back and checked, they did do a reply to the motion to oppose the dismissal. And this was Koil's reply. Let's go through it. This is the brand new court document. The question to the court to decide in the ruling on this motion is whether the plaintiff, which is TOVE, has pled the facts in the complaint sufficient to show an actual controversy between the plaintiff. Goddamn, my voice. Sorry, guys. Was there an actual controversy and a cause of action for breach of contract against Mitchell Clout individually? As the answer to both questions is no. The motion should be granted. Now, this is him still continuing to argue Mitchell Clout shouldn't be a part of the lawsuit, which I'm in agreement with Koil on that issue right there, because who did you enter the contract with? Did you enter it with Mitchell Clout or did you enter it with Koil? And, remember, I have no dog in this fight, but, that's just my personal belief. With regard to the first cause of action for declaratory relief, plaintiffs admit in their opposition that they have not pled adequate facts to state a claim, which they did, hence the amended one. They claim that this was not discussed in the meet and conference hearing. Incorrect, as discussed, infra, but conceded that if they had been aware of these arguments, TOVE's counsel would have likely agreed to amend its allegations to more clearly show an actual and immediate controversy over TOVE's claim to joint ownership of the Nopixel does presently exist. All right. So they're saying, hey, if the plaintiff believes after reviewing the present motion that it should have added additional facts to the complaint, then it should have simply filed an amended complaint, which the plaintiff has an absolute right to do and still can do, which they did. Because remember, this document got skipped for some strange reason. As a party may amend the pleadings, this is just them citing case law saying, hey, you can file for the amended complaint. Now we're about to get a little spicy. Plaintiff, which is TOVE, may certainly amend the complaint to try to correct the deficiencies in its pleadings, and hopefully will file an amended complaint before the 21 days expires so that the court does not have to spend time ruling on this motion. But as currently pled, as set forth in the defendant's motion, there is no controversy at stake, which is interesting because we definitely know there's a huge controversy. So with regards to the plaintiff's claims that during the meet and conference call, defendant's counsel claimed that defendants did not and were not planning to dispute TOVE's claim to joint ownership of the Nopixel server. This is correct. Defendant said no such thing. All right. So they're like, look, we never said that shit. We never said that you guys own half the server. What defendant's counsel explained to plaintiff's counsel during the phone call is not that the defendants were conceding that TOVE was a joint owner of the Nopixel server. What defendant's counsel explained to plaintiff's counsel is that Nopixel was not making any claim to own the copyright to the content prepared by Tracy. All right. So this is where you get into that, their word versus, he said versus she said. This is because the evidence will show that when Tracy began working for Nopixel, he agreed that while he would retain ownership of the copyright to work performed, he was granting Nopixel a perpetual, irrevocable, unlimited, non-exclusive license to use, publish, or republish the content he contributed to the server. Now, look, this is the terms of that right there is going to be hard as hell to prove. Hard as hell to prove. You like, wait, we own this outright, irrevocable. We said that in agreement. You got it recorded. Accordingly, Nopixel is not making any claim to own the copyright in any of the content that Tracy contributed to the server. It is in Nopixel's position that all of the content that Tracy contributed to the server is owned by Tracy or by Tove if Tracy assigned the work to it. Therefore, there is no present copyright dispute between Tove and Nopixel. Now, this is what got me right here. Nopixel will continue to use Tracy's content pursuant to the license he granted, and Tracy and Tove are free to fully exploit all of the work he created. So I ask you, my Twitter users, my Twitch users, is the content still being used? That's all I want to know. Is the content that whatchamacallit created still being used? All right, because if they're still using his content on some license agreement and they are not being compensated for, then that means some money may be owed. That's all I'm saying. And that's my non-legal point. So at no point has Nopixel threatened to sue Tracy or Tove for using the content in other servers. As there is no current dispute or threatened dispute, there is no actual controversy for the court to rule on. I would say this is a huge dispute if you're using licensed content and they're not getting compensated for it. But that is just me. Now, this is him trying to further get himself personally taken off the lawsuit. As he says, there's no personal claim against Mitchell Clout. With regard to the claim against Clout, plaintiff has failed to provide any rational argument as to why he was named individually in the lawsuit. With regard to declaratory judgment action, plaintiff's sole claim is that pleading states that both Nopixel and Clout received money. Plaintiff does not provide any context as to why this argument helps. Clout is Nopixel's founder and owner, so of course at the end of the day, he receives money if Nopixel receives money. All right, so I mean, that is true, but in the amended complaint, they allege that Clout removed him from the server, not Koil. It gets muddy around there. But there is no allegation in the complaint that Clout owns the copyrights in the Nopixel server in his individual capacity. As such allegation would be absurd. I would agree. The declaratory relief action is solely about determining copyright ownership, as there is no allegation that one of the copyright owners is Clout. He is an improper party to this cause of action. Now, he owns it through the company. Now, with regard to breach of contract cause of action, plaintiff's argument is even weaker. Plaintiff argues that there's a cause of action against Clout because the complaint alleges that Clout terminated Tracy's role with Nopixel. Plaintiff does not bother to explain why this helps his case because it doesn't. The complaint alleges that there was a contract between Tove and Nopixel. Nowhere in the complaint does it allege that Clout was a party to the contract, which he was not. Even assuming, arguendo, that Clout fired Tracy, which they did, why would this impose individual liability against Clout? Tove admits that Clout was not a party to the contract, and therefore he could not be sued in the individual capacity for breach of contract. Accordingly to the motion to dismiss should be granted, although if plaintiff really believes that it can fix these problems in the complaint by amending it, then it should do so within the 21 days. So the court is not wasting its time with this motion. Now, Larry Zerner, he actually issued a similar statement to whatchamacallit, where they talk about the meeting that they had, right? Everyone remembers the meeting per se, okay? The infamous meeting where they talked about it. So this is Clout's lawyer saying, hey, during our conversation, I explained to Mr. Tove's lawyer that it was the defendant's, Clout's position that there was no valid copyright dispute because Nopixel did not claim to own the content Tracy added to the Nopixel server. Instead, Nopixel's position was that Tracy retained ownership of the content, but Tracy had granted a perpetual, irrevocable, unlimited, non-exclusive license to Nopixel to use, publish, or republish the content he contributed to the server. So this is where I'm like, yo, who is telling the truth? And this is what happens with paperwork. And I got a video that breaks down verbal agreements if you want to stick around. At no point did I ever tell Mr. Tove's lawyer that Nopixel was not planning to dispute Tove's claim to joint ownership of the Nopixel, or that the defendants were waving the white flag. Now, he's about to disrespect them all the way. I do not know why he states this in his declaration, but as he misstates my name in the declaration, perhaps he did not hear me correctly. Like, God damn. Oh my goodness. And he declared under perjury, this is true. All right. So that was your Nopixel update, guys. What do you guys think? Sorry about that, for letting it slip through the cracks. Guys, I really don't know how it slipped through the cracks, but in the end, it doesn't seem to have any impact on the judge's decision, considering they deemed the motion to dismiss moot.